Compensation in Cases of Miscarriage of Justice, General Comment No. 32, 2007 of Human Rights Committee. 52. According to paragraph 6 of Article 14 of the Covenant, compensation according to the law shall be paid to persons who have been convicted of a criminal offense by a final decision and have suffered punishment as a consequence of such conviction. If their conviction has been reversed or they have been pardoned on the ground that a new or newly discovered fact shows conclusively that there has been a miscarriage of justice, it is necessary that states parties enact legislation ensuring that compensation as required by this provision can in fact be paid and that the payment is made within a reasonable period of time. 53. This guarantee does not apply if it is proved that the non-disclosure of such a material fact in good time is wholly or partly attributable to the accused. In such cases, the burden of proof rests on the state. Furthermore, no compensation is due if the conviction is set aside upon appeal, i.e., before the judgment becomes final, or by a pardon that is humanitarian or discretionary in nature, or motivated by considerations of equity, not implying that there has been a miscarriage of justice.